what I wanted to do is just provide a bit of a framework of what the opportunities, what type of deals you may be looking at in this kind of market, and a few things you may probably already know, or however want to know to bear in mind when approaching deals in these climates. So hopefully this way, yes. So quickly I will look at the type of opportunities, and I thought of approaching these by looking at the final objective, the ultimate goal of the investor. What is actually the investor looking at? And considering both non-performing loans transactions and distressed real estate transaction. Having to say that I'm mainly a real estate lawyer, transaction lawyer, so NPLs, my involvement in those transactions is relative. So my view is that when we talk about NPL deals, we can actually consider two types of transaction. One type of transaction when the ultimate goal is actually to maximize proceeds. So enforce rights, agree with borrowers, negotiate with borrowers, enforce mortgage rights, but ultimately just collect money dues onto those loans. And other type of transactions, I have to say, I've been approached a couple of times, or even more, particularly from the US, by firms that were looking at this type of deal, NPLs deals that were actually aimed at getting control over the underlying assets, or business, depending on the case. Or other type of transaction, pure distressed real estate transaction, whether he's buying from a buyer from a seller that is not insolvent but is at risk of, or buying from insolvency, or buying from forced sale. Concerning NPLs, I thought of providing a bit of overview of what's happening in the market in terms of players and transactions and what the opportunities are. True sales, so just loan portfolios, sales of loan portfolios, or joint ventures between banks, investors, and services, and aimed at not just collecting receivables under those loans, but working with the debtors, providing sometimes equity to improve the actual situation of the debtors. Sometimes acting more in a private equity type of manner than just a typical investor in a non-performing loan portfolio. What we've also seen in Italy, at least according to press reports and articles, of course, growing sector, services sector. And we've actually seen also property investors and mortgage banks that just refocused on provision of services to meet the demand, growing demand from banks. And a few things that have happened on the market, how Italian banks have dealt with their distressed assets and non-performing loans. We've seen quite a few interesting initiatives, setting up of real estate funds that sets up with contribution of assets already possession of banks, and are dedicated to acquiring real estate assets from auctions. And we'll see later that auctions, unfortunately, in Italy, and forced sales in general, are a bit of a problem. And the purpose of those funds and the ultimate goal is to make sure that the sale process doesn't carry on for ages, and it can, and in a way keep up the prices and avoid excessive discounts that could eventually affect the overall value of other assets. Use of securitization vehicles and financial intermediaries set up for the purpose of taking over non-performing loans, setting up private bad banks, and there have been discussion about the opportunity or need to set up an actual bad bank. The Bank of Italy seemed initially against it, now seems to be more in favour of it. Of course, there are concerns about impact on public debt and credit rating. So, to my knowledge, there's no real plan for it at the moment, but we're seeing banks looking on a sort of private bank solution. And what we've also seen is a mix of NPL portfolio with credit service platform, both as a way to offload non-performing loans as well as reduce certain fixed costs and make the whole package more attractive for investors. A quick list of things that, when approaching a non-performing loan transaction, you may want to consider. I think this is pretty general and applies to most jurisdictions, but there are viewpoints that are quite specific to the Italian market. Of course, key part of the process, due diligence, looking at rights, loan documentation, and an important point that's typically not an issue in Italy, but still something that you may want to check every time, is whether the rights under the loan and the mortgage are immediately enforceable, or whether you have to spend time and money in court to get an executable order. Mortgage or other securities, of course, checking that they're properly created and recorded, whether land registry, business register, depending on type of security, and of course looking at the collateral, so the underlying real estate. Whether there are third-party rights, title is okay, that's typically not a problem because there are notary reports just before the creation of the mortgage and soon after that. But despite that, you may still, unfortunately, have a few surprises every now and then. Something that is quite peculiar to the Italian real estate market, not so common, but potentially have a serious impact, risk of any third-party claims that may prevail over your mortgage. And that typically is a no-go for any banks. Typically, banks don't finance, for instance, properties that have been at any point gifted because they are exposed to claims from heirs. But I've been involved in a similar transaction. I've seen a bank financing over almost 100 million with that similar issue, and they didn't even raise a concern. And that was the pre-Lehman era, so in those days certain things just to make the deal could happen, and it's something you may want to look. Attachment enforcement proceedings, although normally a third party cannot prevail over your mortgage, if you're looking at, of course, non-performing loans secured by mortgages, typically third parties cannot prevail, have preference over the holder of the mortgage, but the existence of attachment or enforcement proceedings ongoing could have an impact on your strategy. So you may not actually have all the time that you thought you could have to deal with that. Preferential creditors, limited instances, difficult to check, but for instance, the state could have a right to be preferred of the proceeds for instance, claims for unpaid taxes. Final point, leases and preemption rights. Usually preemption rights are not relevant in a forced sale scenario or in a bankruptcy scenario, but again, like attachment or enforcement proceedings, they may have an impact on your strategy and the time you might have available to extract value from that loan or property. Formalities. Is quite an important point and goes along with the following one: structure and regulatory implications. Formalities, mortgage. If loan is transferred, typically the debtor must be notified of the assignment, and the formalities are required for the mortgage, for other securities like pledges or shares. And that, particularly with large portfolios, very fragmented, could be quite a work. And therefore you may want to consider options that will offer you the possibility of a simplified process and that will avoid all formalities like using securitization vehicles. Something to bear in mind, regulatory implications. Actually, the acquisition of receivable is considered a financial activity, and therefore it's regulated unless it's carried out in a non-professional manner. So single transaction, single loan might not trigger regulatory requirements, otherwise you may have that type of issue. Then, something you probably should consider at the beginning, and how you want to approach, what is your strategy to deal with those non-performing loans. Of course, an option is enforcement of rights, and unfortunately, Italy and the Italian environment, legal environment, is not particularly helpful. State first bullet point, months versus years, because I was talking, knowing that this event was about Italy, Spain, Southern Europe in general. I was discussing with colleagues in Madrid how things work there and what was the average, for instance, time to enforce security over a property. And apparently, you could consider 6 to 9 months in larger courts like Madrid, with more cases, backlog of work, and 2 to 3 months in other parts of Spain and smaller courts. Probably the numbers remain the same in Italy, but we're talking about years. So theoretically, you could look at 15 to 20 months in theory, but as a matter of fact, actual data say that it could say from 30 to 40, best case scenario, up to 90 months. Because there's attempts to sell a property. I think statistics say on average around 4 attempts to sell at auction before the property actually goes. And there are minimum gaps between one attempted sale and the following one. And of course a few possibilities for the debtor to try and resist and challenge the sale. So that has a serious impact on the way you approach. You can't unfortunately just walk in and think of enforcing because we'll be looking most probably at a pretty long period of time. And that period of time could sometimes be even longer by time required by courts to just pay out proceeds unless you're a bank or a financial institution. There may be the need to wait for approval of distribution plan, and that could, depending on the court, take a few months. So unfortunately, enforcement right is not ideal scenario. So the typical approach is actually a negotiated approach. You just don't enforce rights, and this is why also banks, I mean, I'm not too keen on actually enforcing rights on the mortgage because that's really last resort. And over the last few years, a few new mechanisms or creative approaches have been put in place, kind of being called friendly repossessions, sort of sale and lease back involving not the lender but the company of the same group, typically the credit management division or entity. Associated with buyback rights. So basically the property is sold, proceeds are used to pay in full or partly the existing loan, property is let, and there's an option with different kind of contractual solution for the former owner to buy back the property. And another instrument is what's called antiquities, that was long forgotten and is becoming now more and more popular, and involves basically the transfer of another asset, not the mortgage property, and proceeds of those assets, for instance, from lease, can be used to repay the loan that was initially secured by another property. That is pretty much it for non-performing loans, quick overview. And the other type of transactions that could be considered these days is the acquisition of non-performing loans as a way to actually get hold of underlying assets. And in this regard, both in Italy and I think in Spain, you should be aware of a principle which is so-called patria commissoria, which is a prohibition, it's actually a rule of law prohibiting the transfer of title to secure a property, to secure a debt. And that in various manners could become relevant when arrangements are considered to exchange debt for title. So that typically limits the option or creates concerns. Assignment in lieu of payment as part of the enforcement proceedings. I understand that in Spain that again seems to be a lot easier than in Italy. And my understanding, I'm not a Spanish qualified lawyer, is that if certain offers in case of sale at auction are not made meeting certain requirements, above certain thresholds are made, the creditor can actually ask the court to receive the property in lieu of payment, typically for a value that is 50% of the either valued property or the of the debt. That in Italy is also possible, but unfortunately it can be done only at the very early stages of the process, and only for the value of the property that has been determined by the independent expert at the beginning of the property. So actually assignment of a property in lieu of payment at a discount price cannot happen. the discount can only be obtained on the acquisition of the non-performing loan. A deal still be possible, good opportunity, but is not so actually often seen. Of course, there could be other securities, typically pledges of shares, if we're talking about property vehicles. That is quite aggressive, potentially a bit risky, so it is not for all type of investors. But we've seen that used, of course, and that involves taking up the non-performing loans and use secured by a pledge of the company on eventually ultimately owning the asset, and uses the rights under the pledge to get control of the companies. That is a particularly difficult situation and potentially tricky situation, because in that scenario, the creditor and the directors appointed by the creditors are not receivers, they are director of the company, and they cannot just act in the interest of the creditor who appointed them, but will continue to have an obligation to act in the interest of the company, in the interest of the creditors as well. So potentially could lead to a few disputes. Negotiated solutions, that is probably the most common solution adopted, typically as part of a restructuring, and typically involves sale mandates or conversion of that into equity, which is another way of just getting control over the company owning the assets. Sale mandates, I've seen that in practice, negotiated certainly, even with power of attorneys to enable the, in that case, the agent to sell the property, but never really enforced, because again, that could trigger all sorts of disputes and controversy, and you get to nowhere. Still good to have just in case. Final point, perhaps pure distressed asset deals or distressed businesses. First things to bear in mind that if a deal is too good to be true, probably is not true. Meaning that if you are buying a bargain price, you may be subject to clawback actions or avoidance orders, or orders unwinding the transaction that's just been put in place, because it's detrimental to other creditors. So always bear that in mind. Another risk, one of the first risks is typical of insolvency scenarios that may follow, for instance, a distressed asset transaction. The termination of transaction made down the value could also happen without an insolvency, and that may happen if the price at which the property was sold was below the 50% of the market value of the transaction, and the transaction and the vendor was forced to sell the property because of financial distress or similar situations. Then, similar to avoidance and unwind orders, circumstances that could lead to just orders, preferences and transaction defrauding creditors. These are transactions that tend to prefer one creditor against the others, particularly the holder of the loan, and all transactions that may subtract assets to other creditors, particularly in other value. And those are particularly worth noting, because they may, in a insolvency scenario, lead to actually criminal liability. So, but there are schemes, final point, under insolvency loan in Italy, Spain, I think most jurisdictions, that could give you protection and stay, for instance, enforcement proceedings by third parties, protect you from clawback actions, and allow, for instance, restructuring or settlement with creditors, sometimes also with involvement of external investor that typically buys eventually the property after the approval of the settlement by courts.